room. Very well.
It is a fun lunch. Very.
Marbury and Madison is probably the most famous case this court ever decided. The idea of judicial review for constitutionality, I think, is implicit in the constitutional document. But John Marshall made it explicit in the great case of Marbury against Madison.
In all of the Supreme Court's history, there is no one case that says as much to a justice about what it is like to be a justice. Because Marbury versus Madison is the embodiment of judicial review. There's no quotation in all of the history of Supreme Court writing that justices more prefer to repeat than the phrase which says, "It is emphatically the power and the duty of the judiciary to say what the law is." That's a quote from John Marshall in Marbury versus Madison.
We call him the Great Chief. He really was the first person to take the job seriously. He really established the court in a prominent position as one of the three co-equal branches of government. The chief's responsibility is to preside at oral arguments and also to preside at the conference where the justices vote on and decide the cases. That means I get to initiate the discussion and have some responsibility to make sure that all the issues are adequately aired at conference.
There is a change when the new Chief Justice is presiding at conference. Each Chief Justice has his own method of handling and presiding at the conference, and the present Chief Justice is doing an excellent job, and it has some virtues that the others didn't have, but that's pretty much follows the tradition that's been followed for many years.
On the one hand, there's not much the Chief Justice can do. His 8 associate justices have a lifetime job. They have a duty to uphold the Constitution. He can't fire them. He's got to get along with them. We have traditions which will outlast any Chief Justice. And so the Chief Justice comes to a court where there are these elements of stability and permanence and protection. And we have our tradition, and we have our oath. On the other hand, the Chief Justice who presides over our conference and steers us through the mechanics of hearing the cases and calendars, by his personality and his warmth and his decisiveness and his understanding of the law and of the institution of his colleagues can do a great deal to set the tone.
When I got here, my colleagues were very helpful in filling me in on how things worked, often in contradictory ways, but you do get some sense about what's expected in the process. And then you go in and do it and hold your breath and hope they all don't say at once, "Well, what are you talking about? Why are you doing that?" And the real key is that my 8 colleagues were extraordinarily helpful in making me feel very comfortable. I mean, imagine, it's not just that I was...
Virtually it does most of its work in the open. And as they like to say, the work comes in the front door and goes out the front door.
Any change. And you can easily imagine that that would be difficult. But every one of them, I think, went out of their way to make me feel comfortable in the process, for which I've always been very appreciative.
In a moment, go behind the scenes to perhaps the most private and important room in the building, where the decisions of the court begin to take shape.
No one can enter the room who is not a justice, no secretary, no law clerk, not even a message bearer.
I can still remember the first time I set foot in that room and those doors closed. I mean, it's pretty daunting the first few times, because that's where the actual work and the decision-making takes place.
To reserve your DVD copy of C-SPAN's documentary, The Supreme Court.
Advocates face. Justice Ruth Bader Ginsburg, who asked lots of questions, tends to pride herself in a certain tone of civility, and they are very close pals.
And later on this week, watch interviews with all the current and retired justices. Supreme Court Week, tomorrow at 9 p.m. Eastern on C-SPAN. And for more about our
and fair, and each of my colleagues feels the same way. So there's a little tension and excitement in the room, but we love it. We're lawyers. We're designed to do that. The job is no good if you can't argue.
I had spoken once. Of course, I was most junior, but, so it helped me. But I think it's a very good rule. It produces a very good feeling because everyone feels that he's been heard.
It's great to go first because you can tell the rest in a persuasive statement what you think of the case. But when you're on the end of that queue, you do have a certain advantage. That is, you know what the others think.
It is not really an exercise in persuading each other. It's an exercise in stating your views, and the rest of us take notes, and that's its function. You take notes so that if you get assigned the opinion, you know how to write it in a way that will get at least 4 other votes besides your own.
I was the most junior member of this court for 11 years. I had spoken once. Of course, I was most junior, but, so it helped me. But I think it's a very good rule. It produces a very good feeling because everyone feels that he's been heard.
It's great to go first because you can tell the rest in a persuasive statement what you think of the case. But when you're on the end of that queue, you do have a certain advantage. That is, you know what the others think.
It is not really an exercise in persuading each other. It's an exercise in stating your views, and the rest of us take notes, and that's its function. You take notes so that if you get assigned the opinion, you know how to write it in a way that will get at least 4 other votes besides your own.
I was the most junior member of this court for 11 years. And it was always, when we had our conferences, since no one else was in the room, I had the special job of opening the door in case somebody knocked. You know? Somebody knocked, usually somebody forgot a paper. Once they had coffee for Justice Scalia. I said, well, I've been doing this for 10 years. And he said, and I said, I think I've gotten pretty good at it. He said, well, I'm not sure. So we get on very well. I mean, the 9 of us get on very well.
It's informal in the sense that everybody is congenial and there's a certain amount of conversation, but most of it is business.
The justices are actually very thoughtful about what they're doing.
Peace, financial ruin, government relationship with citizens, you name it, we've decided it.
Those discussions lead the justice to conclude tentatively to affirm or reverse in a particular case. Now, that vote is not cast in concrete. You are not walking on wet concrete yet. You can change your mind.
And it's not just win or lose, reverse or affirm. It's what rationale you use, what principle you use to teach something. And if the case is close, 5-4, and let's say you're on the side that prevailed, the majority, there are not a lot of high fives and back slaps, and there's a moment of quiet, a moment of respect.
My most important responsibility is the responsibility for assigning opinions. Once the votes are in, if I'm in the majority, I get to determine who will write the opinion in that case. And that's a very important responsibility because you want to make sure that the assignment is given to the justice whose view commands the most support on the court. You want to make sure the work gets done on time, so if someone's a little slower than others, make sure that person gets assignments, heavy assignments earlier on. Some cases are more interesting than others. You want to make sure those are fairly distributed. Some cases are harder than others. You want to make sure that's fairly distributed. We get all sorts of different issues. You want to make sure each justice has a nice mix. You don't want one justice just doing criminal cases or something like that. So a lot of factors go into that decision, and it's a very important part of it.
When we get through, we sometimes have coffee sent in and maybe eat a sweet roll or cookie or something.
As opinion writing assignments are handed out at the end of conference, a room exists upstairs in the Supreme Court which helps the justices and their staffs consult precedent through the words written in the countless legal volumes housed here. A room filled with not only books, but the symbolism of the great lawgivers, and admired by those few who enter into its mahogany grandeur.
Court cases because those would be in our own chambers, but when looking for secondary materials of different kinds, we would go to the library and we would...
Through the words written in the countless legal volumes housed here. A room filled with not only books, but the symbolism of the great lawgivers, and admired by those few who enter into its mahogany grandeur.
If they want to see the most beautiful room in Washington, they ought to go up to the library on the 3rd floor that nobody hardly sees today. That's not so much Roman classicism as Renaissance classicism, but it is just a breathtakingly beautiful room.
The library is probably one of the most special places in the building. The lunettes, the archways in the library represent science, law, industry. Court cases because those would be in our own chambers, but when looking for secondary materials of different kinds, we would go to the library and we would work with the librarians. It was a wonderful place to work. It was also a quiet place to work.
The library is one of the special rooms in the building. Unfortunately, it doesn't get used as much as it was when the building was first opened, and that goes back to the way the court has changed the way it does things. When the court first moved into the building in 1935, they would literally call the docket each day in court. So you didn't know which case was necessarily going to be argued that day. You had an idea, but a lot of attorneys had to be on site because if their case came up, they needed to go down and be ready to argue it. So that's why you have the lawyer's lounge, which is a place for them to stay while they're waiting to find out which cases are going to be argued. And it's why you have this magnificent reading room here in the library. And this space is reserved for the use of the members of the bar and court staff only.
There have been a few times when I had to use material from so many cases that we occupied 2 or 3 of those tables, leaving the books out so that the law clerks and I could go up there and sit up in the reading room and actually refer to all those passages in the preparation of an opinion.
With precedents and cases researched, in quiet chambers below this library, justices go about the process of writing the opinions, both majority and dissenting, that eventually make their way to the public as the final decisions of the court.
It's an ongoing process. You write a first draft. You figure out, well, I need to know a little bit more about how this case fits in. You go back and read the case. You're always going back and looking at the briefs, always bringing the law clerks in and bouncing ideas off of them. You know, what's wrong with it? It's sort of a continuation of the oral argument process.
Deciding your view of the case itself is terribly challenging. Some of the issues are really tough. Some are not. Some are clear-cut.
Over it. I write, I rewrite, I believe that what we did was right.
I welcome the views of my colleagues on.
Once the person assigned to write for the majority opinion circulates, so all of this,
and they don't pull punches. So I think it ultimately improves the quality of the majority opinion, but it's something you have to anticipate.
Dissents are more fun to write. I got to say that because when you have the dissent, it's yours. You say what you want, and if somebody doesn't want to join it, who cares? You don't want to join my dissent? Fine, it's my dissent. This is what I want to say. When you're writing a majority, you do not have that luxury. You have to, craft it in a way that at least 4 other people can jump on, and actually you try to craft it in a way that as many people as possible will jump on, which means accepting some suggestions, stylistic and otherwise, that really you don't think is the best, but are the best, but nonetheless, in order to get everybody on board, you take them.
If you're just starting out and someone says, I'd like you to change this or that, you're going to be very receptive. When you've got 8 votes and the 9th one comes in saying change this or that, you often say, well, not quite go fly a kite, but the 5th vote is a more critical one. You're more susceptible to making changes than the 9th vote.
The job is to get to it. We're not here in an academy to spin out theories. We're not here producing works that are never going to see the light of day. We're here to decide things. The job is to decide. We decide.
God save the United States and this honorable court.
Justice Alito has the opinion of the court this morning in case 08289, Horn versus Flores. And
this is our moment. The press grab the copies of the opinions and go rushing through. And the guy from Reuters is always the most pushy to get through because he wants to get on the wire service, so you better get out of his way. But the rest of us then go and either dictate or write. The remaining decisions will be issued on Monday. The Supreme Court Public Information Office simply says, here's the material, make of it what you will. But we will make sure you have the material. And that's an enormously invaluable function. And it's also very nice not to have the sense that somebody's trying to spin you.
I personally do go up and want to hear the opinion announced from the bench. I like the pageantry of that. I like to hear the justice himself or herself announce what's in the opinion. Then I race down the stairs to the court press area where we all have our laptops set up now, and I write a first version of that story so that it can get on our internet site. Readers really want to know as soon as possible what the court ruled and potentially what that might mean.
A lot of people say, well, it's a very secretive institution. No, it isn't. It's an institution that virtually does most of its work in the open. And as they like to say, the work comes in the front door and goes out the front door.
You are just a few steps away from the courtroom.
Near the courtroom are two rooms used by the justices to occasionally speak to the public as well. From Thurgood Marshall's retirement announcement to events with other justices over time, one can get a glimpse into the workings of the court and life here. But it is the private view of the ornately decorated East and West conference rooms and their portraits of past Chief Justices that helps one understand the history of the court.
In the East Conference Room, we have the first 8 Chief Justices' portraits. So you can go in there and you can talk about the portrait of John Jay, the first Chief Justice, and how he came to the court appointed by George Washington. And then he gets elected to be governor of New York and decides that that's a better job than being Chief Justice of the United States. So he resigns and becomes governor of New York. And then you have a beautiful portrait of John Marshall by Rembrandt Peale. Here's the great Chief Justice himself in a grand portrait, very similar to the one of George Washington in the Capitol building. And there's a chance to talk about John Marshall, to let people know his story. And that carries through over into the West Conference Room with the more modern justices, where, in fact, you have the 2 instrumental justices in this building. William Howard Taft on one wall and Charles Evans Hughes above the fireplace, looking at each other through time.
I like to go sometimes on a quiet night to the conference rooms because the portraits on the walls, 8 in one room and 8 in the other, are all my predecessors as Chief Justice. To some extent, you look up at them on the walls with a degree of awe, appreciation for what they've been through. They're probably looking down at me with either bemusement or amazement. Each of them has a special story to tell, not only personally, but with the institution of the court. You look up at Marshall and appreciate the importance for him of having the court function as a court, moving the court from a situation where each justice wrote his own opinion and instead saying, no, we're going to have an opinion of the court, which was vital in establishing the court in its present form. Right next to Roger Taney, the most unfortunate of my predecessors, the author of the Dred Scott decision. And you understand that he saw this great problem in the country of slavery and he was going to solve it. And this is how he was going to solve it, and tremendously misguided and injured the court for generations to come. So that helps inform how you look at your own job. You walk down a little further and you see Morrison Waite. You had 1,000 lawyers and law professors and said, who is Morrison Waite? Not one of them would, well, maybe a couple of them would know. And that's a good lesson in, the job doesn't give you a prominent role or historical significance just because you hold the job. You look at Melville Fuller and you understand his role in making sure the court functioned collegially. You go in the next room and you see Charles Evans Hughes and you recall his vital role in turning back the court-pecking plan. And you think about the importance of the independence of the judiciary, things like that. from time to time, I find it a useful reminder of the role of the court and the role of the Chief Justice.
As time moves forward, this building will remain timeless.
People in the United States probably give us credit for trying, even on the days when they think we should have tried harder.
Isn't it wonderful that we also have the ability to rethink issues over time?
Tonight, we talk with William Souter, clerk of the Supreme Court, about oral arguments and how the court decides which cases to hear.
We are in the office of the clerk of the court, and this is William Souter. Hello, Mr. Souter.
How are you?
Thanks for joining us.
Thank you.
Where have you been today? Where have you been this morning?
We had a session in court this morning, and the business was to announce the orders from last week's conference, which only took a minute. And then we had the announcement of two opinions announced by the court. One justice announced both of them. Justice Breyer wrote both of the majority opinions. And then we moved the admission of about 80 attorneys that were in different groups to become members of the bar, and they were sworn in. So largely today was a ceremonial day.
And you are dressed how?
This is the morning coat. It's a very traditional outfit. And here at the court, it's worn by the marshal of the court and myself, and also the Solicitor General of the United States and his staff wear it when they argue cases here. Now, some of the women on his staff do not wear the morning coat. Here, our marshal is a woman. She wears the morning coat, and one of my deputies is a woman, and she wears it also. We traditionally wear the morning coat, the marshal and myself, when the court is in public wearing robes. So when we're in session upstairs, at the State of the Union message over in the Capitol, and at the inauguration of a president. So it's very, very traditional. In the years and years and years ago, all attorneys arguing cases here wore the morning coat. That has fallen into disuse, and now the attorneys wear traditional formal attire.
And do you know how far back that tradition goes?
I really don't know. It's a long time. Things last a long time around here.
Do you know why it's called a morning coat?
I do not. I've looked it up and tried to research it on the website, and there are many stories, none of which are probably true.
Can you turn around for us so we can see the back of the jacket? You have tails.
Yes.
And is it, we call it a morning coat, but is it the whole suit?
Yes, the whole suit, the striped pants, and it's morning, M-O-R-N-I-N-G, as opposed to morning, another type of morning. So it's a morning coat.
Thanks for showing it to us. So you're going to go take a change of clothes
Yes.
and come back and sit down with us
Yes.
for a while? Thank you.
Thank you.
So General Souter, you're back in your suit. This is your normal attire as you
Yes,
work?
yes it is.
And after you finish with the court, what would your normal day be like? What are your duties as the clerk?
The clerk of any court, trial or appellate, is basically responsible for the legal business of the court, not writing the opinions, but being the interface with the public, normally members of the bar of this court who are filing documents here, petitions, briefs in opposition, merits briefs, applications to stay, whatever it might be. My office meets them, receives documents, analyzes them for correctness, for legality, and enters them on the electronic docket. And then we then deal with the attorneys on setting up the argument dates, getting the briefs up to the justices, maintaining all the legal documents for the court.
What's the hardest part of that job?
This is not a hard job. It's a great job. It's an honor to work at the Supreme Court. After all the years I had in the military as an Army Judge Advocate, I missed leaving the Army because the camaraderie, serving your nation, there are a lot of great things about it. But I really found the same thing here. This is a small organization, no politics, justices appointed for life. There's no civil service system. The people that are hired here are the best qualified. And instead of just having a job, the employees here have a sense of mission. to get the job done as a constitutional mission of the court. It's really a high calling, so they look at it as a calling more than as a job. So I'm very happy here and honored to be here. So I don't find this hard. When the justices need something or something needs to be done, we try to anticipate and get it done before it's asked, but whatever's asked, we provide it.
And how many people work for the clerk's office?
For the clerk's office, only 32. And these are mostly paralegals. There are 4 attorneys, but highly skilled individuals.
If we were to see them working now, what would it look like? Can you paint the picture?
It looks very good. They cleaned the file room up because you're here today, and the men and women that work there are dealing with many, many documents. Now, we're very highly automated here at the court, but you still have to have a lot of hard copy documents. We've eliminated much of the paper, but there still is some paper, and they're in there processing the petitions for certiorari that come in. That's someone who lost in a lower court. They're asking this court to hear the case. The other side files a brief in opposition. Those documents have to be maintained in an orderly fashion. They have to be transported up to the justices' chambers to be worked on by the justices and their law clerks. They have to be returned. Documents that are not used then are recycled and so forth. So we have a real system of handling every document that enters this court.
How often do private citizens
to hear the case? The other side files a brief in opposition. Those documents have to be maintained in an orderly fashion. They have to be transported up to the justices' chambers to be worked on by the justices and their law clerks. They have to be returned. Documents that are not used then are recycled and so forth. So we have a real system of handling every document that enters this court.
How often do private citizens bring cases before this court, and have you ever worked with one in which they might not have the legal background that the people of the bar do?
It happens every day. We have about 8,000 petitions asking this court to review the case and hear the case. It's a court of discretion. There are very few mandatory appeals. It's basically certiorari jurisdiction. About 2,000 of those cases are filed by lawyers who know what they're doing, law firms or state entities or the federal government. Their briefs are printed, and they have to pay a fee. We have about 6,000 individuals out there who are paupers. They're poor. About half of them are in prison. About half have an attorney. They, too, under the law, can file a petition here asking the court to hear their case. On the front of this building, in marble, it says equal justice under law. So we really believe that here. Some of these might be frivolous, but each one is looked at and reviewed very carefully. So you have, sometimes people are called jailhouse attorneys. Other people are just individuals who don't have an attorney. It might be a civil case. It could be dealing with something like adoption or child custody or income tax. Anyone can file a document here. Some are handwritten. One of our most famous cases from the early 1960s, Gideon versus Wainwright, was written by a prisoner in Florida, handwritten on prison stationery. His case was granted, it was heard, and it was a very important decision in this case, a right to counsel. Now, not many of these individuals who do not have attorneys are successful in getting their case granted and heard, as you might imagine, because they're not skilled. But they can make a try at it, and maybe they feel better. So we deal with them all the time. And one of our jobs in the clerk's office is to make it as easy as we can for a person to file a document here. Don't hide the ball. The rules of the court are written in plain English so they can be understood. They're posted on our website. We have forms, especially for use for people without attorneys, fill in the blank forms to make it as easy as possible to get the case before this court.
20 years ago, if you would have said to somebody that this court was highly automated or highly computerized, they might have laughed at you. Would it have been true? They should have laughed.
I've been here 18 years, and it's been a very enlightening period for me to be here because we have really totally automated the place. The printing of the briefs, everything we do, the memos written by the law clerks, everything is online. We have very sophisticated equipment, and we have excellent employees in our automation department to help keep everything going. We never hear around here the computers are down. It just doesn't happen. So we're very fortunate in that regard.
This is also seen as a building of great, great tradition. How do you combine the high automation and still keep the tradition?
Well, we thrive on tradition and discipline, and those things go hand in hand. One part of the tradition is when an attorney goes into the courtroom in the morning, before they go in there, I brief them in the lawyer's lounge so they know what to expect that day, to be sure no one forgot a tie or a shoe. Especially rookies sometimes are forgetful. But when they go into the courtroom, the first thing they see on their table are quill pens. They're handcrafted. They're a memento, a gift from the court for a remembrance of their day here at the court. So they don't get an automated pen. They get a quill pen that they can take home with them and put it in a shadow box or something. So that's part of, we maintain the tradition. When an attorney approaches the bench, he says, "Mr. Chief Justice, and may it please the court." That's gone on forever and ever and ever. Each side gets 30 minutes, not 31 minutes. 30 minutes means 30 minutes. So there's part of the tradition, but that's also discipline.
Take us, let's go first to that lawyer's lounge and walk us through that. When do you do this? And let's say you're walking into the lawyer's lounge today to talk to some lawyers.
The attorneys are instructed to be there at 9:15 in the morning. And the regulars all know to be there and come there. Sometimes they don't know each other. You don't know your opponent. It might be New York and California. This is a national court. So it's not just a bunch of attorneys who all hang around the same courthouse. A little different from that. They exchange greetings. They're all glad to see each other. They take their seats, go over the events that are going to occur that day, let them know if opinions are coming down, how many motions for admission, the absences of any justices who might be recused, answer any questions they might have, and offer them cough drops, aspirin, anything like that they might need to make them feel more comfortable. And we have restrooms for men and women in the lawyer's lounge. It's a very intimate place. And the attorney feedback I've gotten over the years is they like it very much. Now, the Solicitor General does not attend, he and his, actually her, I should say, and her staff, because they're here so frequently, they need not attend. But an example, when the Solicitor General, when I came here 18 years ago, he did not attend the briefings. When he left office and went with the law firm, he attended the briefings. And he has told me, since he's now my boss as the Chief Justice, he liked the briefings. He told me to continue them because it is sort of therapeutic. We all meet. We're not just sitting out in the hallway. We gather and go over. Sometimes they have last-minute requirements, and we want them to enter that courtroom prepared and ready, and both sides have an equal chance at winning the case. So that's our job. We don't take sides.
Do you go in a little bit as counselor? Do you find some of them a little nervous about this day in their life?
Yes. I mean, counselor in the sense, not legal counsel, but to speak to them privately sometimes about not to worry, don't be nervous, and they're good. Attorneys are at the right table, petitioners on one side, respondents on the other, 10 o'clock case, 11 o'clock case, check to see if there's anything they need. I then talk to the people who are making the motions for admission. Be sure they have their motion, that they know what to do, where to stand, when to speak. And those that are being sworn in, I brief them on exactly what they're supposed to do. They don't want to come to the highest court in the land and stand up and not know what to say or do. So we go over it with them very carefully and explain what's required. And I generally check around to be sure we're ready to go. And I then talk to the people who are making the motions for admission. Be sure they have their motion, that they know what to do, where to stand, when to speak. And those that are being sworn in, I brief them on exactly what they're supposed to do. They don't want to come to the highest court in the land and stand up and not know what to say or do. So we go over it with them very carefully and explain what's required. And I generally check around to be sure we're ready to go. And at 10 o'clock sharp, we start.
Ever late?
Never. Now, a lot of people are doing a lot of work. Our police, the marshal, the aides, a lot of people are getting the lawyers in to be sure they're seated. The members of our bar, they're seated up front. All the spectators, everyone is there ready. They're in there early. The press is even there on time, believe it or not. Everything's very orderly and respectful. There's a 5-minute buzzer, and means 5 minutes and we're ready to go. And then the justices appear behind the curtains. The curtains open in 3 places, and the justices enter in groups of 3, and the marshal cries the court in with her traditional cry, part of which is "Oyez, oyez, oyez," which is used throughout the country to announce the arrival of the court. And the justices enter and take their seats. Everyone rises, and it's sort of an inspirational moment. People say, I couldn't believe it. There they are. They're really there. Chief will say motions for admission first, maybe an opinion coming down, and then he says, we'll now hear argument in number 08410, Smith versus Jones, Mr. Holtz. And Mr. Holtz says, Mr. Chief Justice, and may it please the court. They know where to stand. They're up there. Nobody's wandering around. First and second, because you're sitting there second, just sort of waiting and waiting. But that's the way it is. And sometimes they'll get up and leave the room for a minute and come back just to take a little stretch or something. Get that for them. But it's a part of the tradition. Questions, they're very, very well prepared.
So you've explained very well how your interaction is with the lawyers and with the outside. Talk a little bit more about your interaction between you and the justices in your normal everyday.
We then retire to our office, double check everything, and then prepare the orders of the court, which are then released the next Monday. I said this morning, the first thing the chief said when the court opened, the orders of the court are certified and filed by the clerk. They will not otherwise be announced. Those orders then are released. They go on the internet. Public information lets them out, and all the people that are interested, including journalists and members of the bar and the public, they know which cases are granted that'll be heard next term.
And when you get that briefing from the junior justice, do you know what happened in terms of the discussion?
No. We just get the results, and it just takes a few minutes, and it's a very pleasant time with them. I got to tell you, I'm still awed by the building and the institution. I mean, I've been a lawyer for a long time before I went in the Army JAG, and then I was a lawyer for almost 30 years, and a lawyer here doing legal, administrative, and clerical type in the courtroom rather than